Hello, folks. This is Eric Sinrod at Duane Morris in San Francisco, an international law firm with offices around the world. I'm so happy to be here with Jonathan Armstrong from Cordery. We're bringing you your regular TechLaw10 podcast where everything technology and the law intersect. We're the place to be. We're at ground zero. And Jonathan, my friend, apparently you've been thinking about potential personal liability of individuals relating to tech issues. So can you crystallize that for us, please?
Yeah, I will. Yeah. So I spoke recently at the ISMG conference and we had quite a debate on this. And I think I'm certainly seeing a trend of individuals being personally responsible for the tech issues of their businesses. Now, of course, the Joe Sullivan case is well known and would be an example in the US. But over in Europe, we've had cases as well. So recently, Dame Alison Rose resigned from a bank because the bank had been in dispute with one of its customers, a politician called Nigel Farage. I think you've had the pleasure of Mr. Farage on your side of the pond as well. And effectively, she released information about Mr. Farage's banking to a journalist. And then they also had a difficult journey with subject access requests made by Mr. Farage. And then he effectively offered himself as almost like a consultancy service to other people who were aggrieved with that bank. And as a result, the bank had to make statements that it was still solvent despite the added burden of those subject access requests being made under GDPR. And we've also had another banking case involving an individual called Carlos Abarca. He was the former CIO of another bank. He was fined by the financial regulators in the UK in April for failure to properly deal with his senior manager responsibilities with an IT transition. And what effectively happened here was the bank was acquired by another bank, and the acquirer bank was trying to move its systems into the acquired bank. And Mr. Abarca was the guy responsible, if you like, for that transition. He had worked for the acquiring bank previously, and he was, I think, over optimistic about how well that IT transition was going. And as I said, he was fined by the financial regulators effectively for that optimism. Now, one of the interesting things here is that the financial regulator looked at Mr. Barker's LinkedIn profile and said effectively that because he'd put that he was an expert in transition and change and stuff like that on LinkedIn, then he was judged by that. Then he would be judged by that higher standard. And as you know, Eric, I've had my mini tour of North America over the last 3 weeks. So I've spoken at the Relativity conference in Chicago, an excellent panel chaired by David Horrigan there. I spoke at the Society for Corporate Compliance and Ethics in Chicago and at the New York State Bar Association meeting in Mexico City. And we've had debates at all of those conferences about how this trend applies to AI. And I don't think it's too much of a stretch. Clearly, a lot of people have been frantically updating their LinkedIn profiles to say, and I'm now an expert in AI. And will that come back to haunt them? Now, I should say at this stage that I'm on the New York State Bar Association AI task force, but you should regard what I'm about to say as my personal thoughts rather than a sort of a steer to the future as to where the task force might end up. But
You
it
don't,
seems to
you don't sound like a New Yorker.
no, I disguise the accent well. I think
Yeah.
I'm the token alien on the panel. But one of the things I think that is interesting is that what are the obligations as lawyers to understand AI? And obviously, many bar associations around the world have reminded lawyers of the need to be technically competent or to at least phone a friend if they're not, particularly in the area of cybersecurity, where many bar associations have reminded lawyers that it's their obligation to make sure that the technology they use is secure, that they have to read terms and conditions when they use apps or cloud services or whatever. And it seems to me that there's not too much of a stretch to say that that professional obligation of lawyers, and we could say potentially of other professions too, extends to an obligation to either understand AI or find somebody who does. And to give you one quick example, there's a scandal emerging in the UK currently over something called the Horizon investigation. Now, this relates to the post office's use of an IT system, and that IT system was defective, but evidence from that system was used to prosecute postmasters who were generally self-employed officers, if you like, who ran post offices round the UK, and 736 of those postmasters were prosecuted, possibly all because of deficiencies in the Horizon system. Of those, 60 died before they were pardoned, and at least 4 of those were suicides. They couldn't deal with the shame of being charged and in some cases convicted and in some cases imprisoned because of criminal offenses. And a large law firm and a Big Four accountancy firm were meant to be dealing with discovery in that case. And the allegations are there were some 54 million documents, so this wasn't a small exercise. But the allegation is that the team dealing with the discovery exercise resisted technology that could have streamlined the process. It is alleged purely because they wanted to preserve their profits. And obviously, the business model in some exercises like this is law firms get money and accountancy firms get money for the amount of humans involved. And if you can maximize the human involvement at an hourly rate, then you make more money versus the use of technology. And it is alleged that the law firm involved recruited graduates, not even fully qualified lawyers, in Belfast, in Johannesburg, and in Melbourne. And the allegation is that they looked at the profit from the hourly work of those graduates rather than looking at technology, including AI, that might have streamlined the process and may even have made it more efficient and got to the relevant documents more quickly. And as I say, I was at the Relativity conference in Chicago about 3 weeks ago, where it's clear that a lot of this technology is very good and some of it can be proven, particularly if you've got an exercise involving 54 million documents, then clearly you've got enough documents to run a sample set using technology and a human reviewed set so that you can compare the results and make sure that the machine's working. So it seems to me that it's not too much of a stretch to say IT professionals need to understand AI, particularly if they're putting it on their LinkedIn profiles, and lawyers do as well, or at least to explain to the client where their competencies lie and how any gaps in their knowledge can be supplemented if it comes up to a relevant case, which might be an M&A transaction, it might be e-discovery, it might be a data breach type case where possibly technology could help. And I wonder if you'd seen any of that trend on your side of the Atlantic, Eric.
Wow, that was a tour de force. Plainly, you've been on the speaking tour because you have a lot to say and you did it. But how to unpack, we use the word unpack that, right? I'll just say a few things, if I may, to try to be efficient. Of course, we have, you led with the idea of potential personal liability of information security officers. And I know I looked at one of your talks, you sent it to me, thank you. And the idea being sometimes companies might not take data breaches, for example, as seriously if that's sort of the cost of doing business and it gets passed on as sort of charges to customers down the line. Whereas if there's potential personal liability, that gets the attention, right? If you personally could be fined or imprisoned, that makes you stand up and take notice. And we do have in the states, data breach notification laws at the state levels, and it's very important, first of all, on the front end to try to prevent hacks and data breaches, obviously. But if they happen, there needs to be some sunshine on that and some clarity and some potential remediation to users and customers. And I know you talked about not going it alone and information security officers and partnering with in-house counsel. And if that's not adequate or available, with law firms. And that is important, on the front end, try to make sure as a team that leaks and breaches and hacks don't even happen. But if they do, how are they handled properly, remediated and prevented in the future? And also by having counsel involved, that does afford the potential for attorney-client privilege. And then also, sometimes there's what's called the advice of counsel defense, too, for a company to say we were following what the attorneys told us, although once you do that, the privilege is gone. You've opened everything up. So that's an initial thought. I'm glad you talked about LinkedIn and social media, because so many times in the United States in litigation, what is said or done on social media comes back to bite in the courtroom, because people are pretty loose and informal. And people can throw around, yes, I'm an expert when it comes to AI, but it's difficult to be and sustain being an AI expert without continuing education and thought, because it's changing on a nonstop basis. And there has been an example of one law firm in the United States. You sort of talked about how AI can be quite useful and accurate at times, but not always. And if we take the lawyers completely out of the equation and have AI acting in place of lawyers in terms of legal submissions to court and whatnot, oftentimes what's submitted is incorrect. The citations are missing, the legal citations, or they're wrong. So we have to be very careful. And there's a lot of reticence about that. And it's not reliable enough to supplant attorneys. And we certainly don't do that. And then what was my other point about that? But I think you are right, though, that as a team, it is important to give advice and understand AI. But like I said, it's a train out of the station. It's constant. Well, it's not a very good metaphor, is it? But it's a train that keeps picking up speed and changing along the way as it goes down the tracks. I don't know if that worked or not. And I teach about this quite a bit. And it's interesting because, when I teach my tech law courses at the university level, I'm telling you, Jonathan, even a year ago, we weren't talking that much about AI at all. And now it's all we talk about. So those are initial thoughts of mine. I don't know if I responded. I don't even recall your initial question, but you planted enough of a seed, so you got what you got.
No, I think that was really helpful. And I think you're definitely right that we've tried to deal with some aspects of AI in earlier films, which are still up on the website. But I wonder if this whole expectation thing is going to be really difficult to manage, because clearly we have people who are early adopters and are adopting technology without understanding the risk. But at the same time, we have people who are trying to put their hands over their ears and close their eyes and sing happy songs and pretend that AI doesn't exist at all. And I suspect that the balance has to be somewhere in between. Of marginal interest, there's a big piece of work from the French privacy regulator in the last week or so, where they've effectively said, well, similar to what I'm saying, really, you have got to look at this risk head on. You've got to have a methodology to look at it. And they've said some aspects of AI aren't novel, so they don't require you to go through the full data protection impact assessment process in some cases. But I think the default mechanism is going to be that you're going to have to properly plan AI. And I think getting back to where we started, if you don't, there's potential personal liability as well as liability on the organization that you work for or represent.
Yes, I agree. we could keep talking about this for days, and I'm sure we could, but in the interest of brevity, we should probably wrap it up. Although when you were just talking, I had 10 more thoughts, but we'll save that for another time. I'm so glad to see you. I'm glad your trip went well. I'm sure you enlightened many people. I certainly learn from you all the time, and it's a nice conversation we have. So I'm Eric Sinrod at DwayneMorris.com. I'm real. I'm not AI so far. I'm not an AI hologram.
Yeah.
You can reach me at ejsinrod at DwayneMorris.com. Go ahead.
Fabulous. Thanks for the kind words. I'm sorry that my trip didn't get to California this time, but maybe in future. I'm Jonathan Armstrong, jonathan.armstrong@corderycompliance.com. I think inevitably we will return to this topic. Jonathan.armstrong@corderycompliance.com. I think inevitably we will return to this topic. We'll put the link in our LinkedIn group, just TechLaw10 on LinkedIn. If anyone else wants to pitch in with thoughts, how we insure the risk, what tips people can have to prevent bad things happening to them, then feel free to join the debate there. All that remains is to thank you all for watching/listening, and we'll connect with you again in a few weeks' time.
Thank you so much. Goodbye.